Day 2 of Ethics Week. My name is Fran, Vann. I'm an attorney with the Board of Ethics and Government Accountability. Today we're going to talk about ethics and legislative updates. So with that, we'll get started. Next slide. Okay, next slide. So you are, or most of you are familiar with the residency requirement, which requires most representatives to live in the jurisdiction in which they represent. And so DC also has a residency requirement, but this particular case, we're going to talk about the New Hampshire residency requirement. And in this instance, a member of the New Hampshire legislature resigned abruptly after being under investigation for not being in compliance with the residency requirement. So investigators concluded that Troy Murner, a New Hampshire Republican, no longer lives in the district he represents and hasn't since August 2022. He currently resides in Carroll, New Hampshire, which is another legislative district. He has been residing with his new wife and stepson since his first wife passed of cancer in January 2022. So when he remarried in September 2022, he moved to reside with his new wife in Carroll, which was a different legislative district. Next slide. So Murner has also been collecting mileage reimbursement from his work location to his previous address, despite no longer living there. His colleagues stated that it's appalling that he knowingly misled the community, undermining our democracy's core foundation. An assistant attorney general for the election law unit wrote that there is no ambiguity about the constitutional and statutory provisions that require lawmakers to inhabit the districts that they represent. So here he is clearly misusing government resources by claiming a mileage reimbursement when he no longer lives in the district that he claims to be. Next slide. Okay, so now we're going to talk about gifts, and this particular instance is regarding the sale of land. Can you guys hear me okay? Sorry. Okay. So the issue here is Knox County Ethics Commission in Tennessee is considering a complaint filed against a county commissioner and a well-known developer over whether a property sale violated the county ethics code. So in July, Scott Davis of Masana Investments transferred ownership of a plot of land to District 4 County Commissioner Kyle Ward. So Ward paid $10 for the land, which the county appraised for more than $50,000 according to the deed. And so that automatically sends up red flags. If someone is offering you, gift, like say it's an iPad and it's valued at $3, and you give them, $5 in exchange, that's going to lead to some, issue, or there's an issue behind there's an issue behind the difference in the value of the gift. And so if you do get a gift from an outside source and you want to keep the gift, you should pay the fair market value. It shouldn't be an uneven exchange. So next slide. So the complaint alleges that Ward accepted a gift of over $50,000, which violates Section 4 of the county's Code of Ethics. Davis, the developer, stated that Commissioner Ward acquired the property to build a house that Davis would then sell to recoup his portion of the value of the property. So Michael Covington, the chair of the Ethics Committee, said that Davis never laid out until after the ethics complaint was filed how much Ward would pay for the land, and that's the key component of the complaint. So Mr. Covington said, I find it difficult to believe that a $50,000 piece of property gifted to a sitting county commissioner doesn't warrant an investigation by the Ethics Committee. And again, we see that this is a gift from a prohibited source. And if you are going to take a gift from a prohibited source, you must pay the fair market value of the item. Next slide. So now we're going to talk about lobbying gone wrong. And so in this instance, Richard G. Olson Jr., a former U.S. ambassador to Pakistan and the United Arab Emirates, was sentenced to 3 years probation and a $93,300 fine for violating federal lobbying and ethics laws. Olson admitted that when he was an ambassador to Pakistan in 2015, he failed to disclose that he received an $18,000 first-class ticket to fly to London for a job interview with a Persian Gulf investment firm. He also acknowledged that he illicitly helped to lobby U.S. officials on behalf of the government of Qatar in 2017, violating a federal cooling off law that prohibited him from doing so for a year after his retirement from the State Department in November 2016. Next slide. So in tearful remarks, Olson told the judge he regretted the action that got him in legal trouble. He said, "I did step over the line. It was a mistake. It was not intentional." And so just how we had, or the federal rules have a 1-year cooling off period, we have that as well in our post-employment restrictions. And so we always advise that before you begin seeking and negotiating employment with a private entity, that you come talk to us so that we can give you advice so that you can avoid, situations like this. We also see that he, also accepted a gift from a prohibited source. And then we want to note the importance of, if you do get a gift under $10 or a gift in general, you should report it on your financial disclosure statement. Next slide. Okay, so this one is a little more local, and you'll see that the title is a play on words, master manipulator. So this occurred in Baltimore. And in this instance, Baltimore Inspector General Isabel Mercedes Cummings presented the case of a city worker who, seeking a promotion, manufactured a master's degree after first fabricating a college degree that got her the job in the first place. So the employee began at the Bureau of Accounting and Payroll Services 2 years ago in a position that required a college degree that she certified she had, but she didn't. So no one checked her educational history when a promotion requiring a master's degree came up, the employee informed her supervisor that she had once enrolled in a master's degree program at the same college. So while her initial job application did not list any master's degree, the employee said that she had contacted the college registrar and was informed that she did graduate from the master's program, but the degree was never mailed. Next slide. So the employee then requested that BAPS accept an updated resume that now included a master's degree from the local college, along with a transcript and photo of the diploma for the master's degree, which they allege to have achieved in May 2001. So OIG subpoenaed the college to verify the degrees and found that the employee had never completed a single semester at the institution. There were no transcripts, and the photographed master's degree was a fake. So to avoid such fraud in the future, Cummings called on Mayor Brandon Scott and the Department of Human Resources to set up protocols to ensure education verification checks are completed and appropriately reviewed as a part of the hiring process, especially in the case of financial positions with access to sensitive information. And so in this instance, she's just being dishonest from the jump, which comes with a lot of ethical violations, as you can see. Next slide. Now we're going to talk about gifts in the form of tickets. So the Florida Commission on Ethics has officially opened an investigation into Miami Mayor Francis Suarez following a complaint regarding his acceptance of expensive tickets to sporting events like the Miami Formula One Grand Prix and the 2022 World Cup in Qatar. Next slide. So there are questions about who paid for the various tickets worth thousands of dollars and whether Suarez complied with the Florida ethics laws requiring the mayor to disclose the source of all gifts, including complimentary access valued over $100. The laws also prohibit elected officials from accepting such gifts from city vendors, lobbyists, or their employees. Like I mentioned earlier, similar to ours, where you can't accept gifts from prohibited sources. And then billionaire hedge funder Ken Griffin previously told the Herald that he invited the mayor and his wife to the dinner in the Sunday race, events with a total value of $14,000. Griffin is currently lobbying the city as he plans to move the headquarters of his company, Citadel, to Miami. And so here it also gives the appearance of impropriety that he's inviting him to these lavish dinners and events, to gain favor so that they can move the company. Next slide. So Griffin's spokesperson told the Herald Suarez had covered the cost of the ticket. Suarez has not provided receipts documenting the repayment and declined to answer the Herald's questions regarding when he repaid Griffin. Suarez had until the end of September to report the dinner tickets and any other yet unknown sources behind this Grand Prix weekend that ran from May 5th to May 7th. However, he is not required to report tickets he paid for himself or those he fully reimbursed within 90 days of attendance. Next slide. Okay, so now we're going to talk about post-employment and then a little bit of judicial ethics. In this situation, there are allegations that Judge David Boynton acted contrary to multiple ethics provisions when he discussed his future employment with the Montgomery County State's Attorney's Office while hearing cases. So over the course of at least 6 weeks, Boynton negotiated and accepted a job offer from Montgomery County's State's Attorney's Office without disclosing the pending move to at least 18 defendants or their attorneys who appeared before him, according to court recordings and documents. The Office of the Public Defender has filed a motion for outside prosecutors to conduct a possible new trial for some of those cases. And then officials at the State's Attorney's Office, where Boynton now heads the Felony Trial Division, denounced the motion as baseless and without merit. And so here, of course, it does give the appearance, again, of impropriety. He's negotiating with the prosecutor's office while he's presiding over their cases. So a defendant might think that he can't be impartial or, he might lack fairness. And in this instance, it would be appropriate to recuse. Next slide. Okay, so the former Anaheim mayor, Harry Perdue, has agreed to plead guilty to federal charges in connection with his push to sell Angel Stadium, including lying to FBI agents about not expecting to receive anything from the Angels when the transaction closed. So he allegedly hoped to get a $1 million campaign contribution. Perdue also destroyed an email where he provided confidential information to the team about the city's negotiation. He had planned a mock city council meeting in advance of the sale to rehearse talking points. And in an email setting the agenda for a mock council meeting scheduled to take place September 21st, 2020, he laid out a detailed plan and noted that he wanted to play himself, and he is expected to be a strong defender of the deal and know its terms, at least at the policy level well. And so as you can see, he's, gaining some type of financial benefit from the participation, and at this point, he should have recused himself as well. Next slide. So now we're going to talk about some proposed legislation, and this is regarding the Supreme Court. So Senate Democrats are pursuing legislation that would set a binding ethics code for the U.S. Supreme Court following revelations that some justices have failed to disclose luxury trips and real estate transactions. The Judiciary Committee held a hearing on Supreme Court ethics concerns in May, but Chief Justice John Roberts rebuffed the invitation to testify, citing the importance of preserving judicial independence. Next slide. So the requirements of the Supreme Court Ethics Recusal and Transparency Act of 2023, the bill requires the Supreme Court to adopt a code of conduct for justices and establish procedures to receive and investigate complaints of judicial misconduct, adopt rules governing the disclosure of gifts, travel, and income received by the justices and law clerks, but are at least as rigorous as the House and Senate disclosure rules, and establish procedural rules requiring each party or amicus to disclose any gift, income, or reimbursement provided to justices. Next slide. Some additional requirements expand the circumstances under which a justice or judge must be disqualified and it also requires the Supreme Court and the Judicial Conference to establish procedural rules for prohibiting the filing of or striking an amicus brief that would result in the disqualification of a justice, judge, or magistrate judge. Next slide. Okay, so not only is the Supreme Court facing scrutiny, but lower courts are as well over ethics disclosures. So Fix the Court, a watchdog group that advocates for greater transparency in the judiciary, estimates that only about 17% of the court system's disclosures for 2022 have been posted online. And so even though most of those reports were due months ago, they still haven't been posted. U.S. Circuit Judge Levinsky Smith, the Chief Judge of the U.S. Court of Appeals for the 8th Circuit, told reporters that court staff is working diligently to make sure the backlog of past judicial disclosures is closed, but offered no specifics on when the actions were taken to address the issue. Federal judiciary officials have said the biggest issue is the lack of resources needed to parse the reports once they are filed. Next slide. Okay, so now we're going to talk about your social media use in a professional versus personal setting. So employees' personal use of professional networking platforms is generally permissible under the standards of ethical conduct. Employees must be particularly mindful of implying governmental sanction or endorsement of their accounts. If employees make reference to their official positions in their professional networking accounts, they are encouraged to use disclaimers. And for example, the views and opinions provided herein are my own and do not necessarily represent the views of the agency. Next slide. So the permissible use of professional networking platforms. An employee can note their government affiliation, title, or position in the employee's background section of their user profile. Employees can use an official picture or a picture of themselves at a work event as their profile picture. However, such pictures must not disclose non-public information. So if you're in a boardroom and you have a classified document, you shouldn't take a picture and then post that information on your social media account. And then generally, employees can repost notices like job announcements, updates, etc., that their agency posts. Next slide. Okay, now we're going to talk about monetizing personal social media. Next slide. Employee engagement in income-producing social media activities will not always implicate the standards of ethical conduct. However, employees may not engage in monetized personal social media activity that would conflict with their official duties. And it's a good idea for employees to check with their ethics office before taking steps to monetize their personal social media account. Next slide. So recusal might be important or should be important if an employee is an influencer or brand ambassador of a company. Then the employee would be required to recuse from any particular matter involving specific parties in which the company is a party or represents a party if a reasonable person would question the employee's impartiality. So say you work for an agency and Nike has asked you to be their brand ambassador, and then Nike comes before you at your agency, you should submit a written recusal to your supervisor as well as our office, just letting them know that you are a brand ambassador and you can't handle the matter. Next slide. Okay, so now we're also going to talk about some more updates. So this is regarding the Philadelphia Board of Ethics, some regulation amendments. So now they require new employees to attend ethics training within 90 days, and this moved from 120 days. So the next update, within 15 calendar days of the effective date of employment or the beginning of a term of service, each city officer or employee shall acknowledge in writing that the officer or employee has received and reviewed a copy of the city's ethics laws. And as Director Cooks mentioned in her welcome yesterday, we require this as well. You do have to take an ethics pledge when you do your new employee orientation. Annual training, so city officers and employees must attend training at least once in each calendar year. And there's a civil penalty of up to $250 for failure to attend a training. And then lastly, an agency head shall be subject to a civil penalty of up to $250 for failure to provide a copy of the ethics laws to a city officer or employee. Next slide. Okay, so now we're going to talk about Maine Ethics Commission updates. So the Commission on Governmental Ethics and Elections Practices published legislative summaries and updated guides to reflect legislation passed in 2023. Effective October 25th, the window to register as a lobbyist is decreased from 15 to 10 calendar days following triggering activities. The penalties for lobbyist reporting violations will increase by $50 for each successive violation during the lobbying year. And then lastly, effective June 22nd, the ban on direct corporate contributions was reversed and now limited to $19.50 in an election for a gubernatorial candidate, $475 for a legislative candidate, $575 for a candidate for municipal office, and $975 in an election for any other candidate. Next slide. And now we're going to discuss Chicago's proposed amendment. And so Chicago has taken a different approach. They are now putting the onus on contractors to make and report ethical violations. So the first is the duty to report and whistleblower protections. So the proposal would make clear that city council contractors who have information concerning corrupt or unlawful activity are obligated to report such conduct to the Office of Inspector General, just like city elected officials or city employees with or for whom they work. Next slide. Improper influence. This proposal extends the first of two conflicts of interest prohibitions to city council contractors. It would prohibit them from getting involved in any city decisions benefiting or affecting their financial interests, like their other clients or employers, or in matters in which they stand to receive or have received income or compensation for a full year before and after the matter is pending. Next slide. Okay, and then lastly, they have amended their restricted political activity. So the change to subpart 7 of this definition and to subpart 9 and the definition of political activity is intended to make clear that city officials and employees may neither personally drive voters to the polls nor arrange for someone else to transport them to the polls. So during this past election season, the board issued several informal advisory opinions to candidates and their representatives that transporting voters to the polls or even arranging such transportation is prohibited. This change clarifies the advice in plain language. It is not intended to curtail the ability of private groups to voluntarily engage in voter drives or to transport voters to the polls, as long as no candidate or city official or employee is involved in arranging or planning such drives. Next slide. And with that, that is the ethics and legislative updates. Next slide. If you have any questions or if you need to discuss anything with us, you can email us. Yes, I will send out the presentation or give us a call. But thank you everyone for your time and attention.